The Tennessee Supreme Court will decide if shoplifters can be charged with a felony instead of a misdemeanor. It's been going on for a while now in our area. WATE 6 on your side legal analyst Greg Isaacs joins us now. It's good to see you.
Good to see you, Lori.
A little bit of the backstory. Knox County DA Sharm Allen decided 3 years ago to toughen the charges for criminals who keep stealing from stores, well, more than once, twice, and then over and over again in some cases. Many attorneys don't like this, Greg. Why?
Well, a lot of the attorneys and defendants are up in arms. And here's how this started. In 2016, based on the opioid epidemic, which one of the fallouts is a shoplifting epidemic, prosecutors in Knox County attempted to change their policy on shoplifting. So what they did, if you have been convicted of shoplifting, and Walmart was the lead victim, and you're on a no trespass list, and you go back and shoplift the second time, they are saying and charging legally that you have committed a burglary.
So why don't people like this?
Well, it's a dramatic difference. This is now trickled all the way up to the Court of Appeals. Putnam County is the only other county in Tennessee that has this policy. A recent Court of Appeals opinion said no. You can't change the penalty for shoplifting by calling it burglary.
They called it a prosecutorial overreach.
Right. And here's what, for burglary, you have to break into the dwelling of another or a business that is closed. Walmart is open 24/7. People are there as invitees. Isn't
this a deterrent, though, to shoplifters who keep going back?
One of the lead cases, someone is doing 12 years for stealing $39. Another case a few weeks ago, a 59-year-old impoverished grandmother was stealing food, and she was looking at a felony. Just last year, the legislature raised the amount that it is required for felony theft from $500 to $1,000.
So ultimately, what do you think the Supreme Court might do, and how did it get that far?
There is a tremendous equal protection argument, because if you shoplift at Walmart in Sevier County, Cott County, La Follette, Davidson County, it is shoplifting, which is a misdemeanor. Knox County, Putnam County, a felony that you can go away for a lot of years. In a very rare move, the Supreme Court has invited other legal scholars to weigh in, to file amicus briefs.
That is rare.
It is, but what the Court of Appeals recently said, if the legislature wants to change the penalties for shoplifting, it is their constitutional mandate, not the will of the prosecutors. So it's really going to be interesting. But Lori, shoplifting, not a good thing. It costs literally billions of dollars a year, but people are getting locked up that are stealing a few dollars.
One thing before you go, I talked to the DA today, and she said juries agree with her. On the whole, they agree with her on these tougher charges.
Well, let me tell her, defendants disagree with her on a whole. So, you know, and I don't think they know the backstory, and juries don't know what you're going to be sentenced to, so they're not privy to all that stuff. But, you know, it's a misdemeanor. If you have 3 cats and you call one a dog, how many cats do you have?
There you go.
There you go.
I got it.
A shoplifter is a shoplifter is a shoplifter.
All right, Greg, thank you.
Thank you.
All right, we'll keep you posted on what happens here with the Supreme Court and this issue. And if you have a question for Greg, just send an email to askisaacs@wate.com. And be sure to tune in to WATE 6 on your side news at 5:30 every Wednesday to see if he answers your legal question.